In this lecture, we will discuss about the various high courts of India in their judgments on LGBT queer community. So, in the very introduction, as in relation to India, we found immemorial instances that were found in the mythological traditions of India as many instances and references were made in the Mahabharata, in particularly regarding the transgender character of Srikhandi in Mahabharata. Then Arjuna, another important character in Mahabharata, portraying as a transgender lady dance teacher in the royal palace of King Virat, so as Brihatnala. And also we found references regarding the transgenders and lesbians and gays community in the temples of Khajuraho in Madhya Pradesh and in Konark temple in Odisha. So we found references about the queer community in the works of Bhashayana's Kama Sutra and Bharata's Natya Sastra. So also we found many such references in other Jain and Buddhist texts. So also it found continuing during the Delhi Sultanate and Mughal period. Only during the British period, the Britishers, when they came to India after a long period, they introduced a new section into Indian Penal Code, that is Section 377, by the then Lord Macaulay, when he became the first chairman of the first Law Commission of India appointed by the British government and British Parliament. As the Britishers, they had their Buggery Act of 1533, where they declared sodomy as an unnatural offense, and committing such offense would be punished with death sentence. So, the Buggery Act of 1533 and the very provision was inserted into the Indian Penal Code under Section 377 of the Indian Penal Code, which considered and declared it as a natural offense. So the punishments varies as per the nature of the offense. So it became an issue among the queer population or the transgender population in India, and many legal and political and social movements came over. And in that connection, we have discussed in our previous lectures some landmark judgments delivered either by the Delhi High Court and the Supreme Court, in particularly in the case of Naz Foundation versus the Government of National Capital Territory of Delhi in 2009. Then subsequently the landmark judgment delivered in 2014 by the Supreme Court in National Legal Services Authority versus Union of India and later on the most important and more judgment delivered by the Supreme Court in Navtej Singh Johar versus Union of India in 2018. So, in pursuance and in the compelling situation, the Indian government and the Parliament of India enacted certain laws relating to transgender community and the LGBT community, and such laws first, if we found made any reference, then it was in the Mental Health Care Act of 2017, which already we have discussed in detail later on. The Parliament of India enacted the Transgender Persons Protection of Rights Act 2009, and so also in 2020 when the labor code were enacted, such as relating to the occupational health, safety, and the very code provided some reference to the LGBT community. So, in that context, that we have discussed the very important role played by the Indian judiciary, in particularly the apex court or Supreme Court. In that context, we have discussed some relevant judgment which delivered by the apex court, in particular in 2014 and 2018, which made substantial contribution, and those judgments compelled the Parliament to enact those laws. So, in this lecture, we will exclusively discuss the judgments delivered by almost 10 high courts that we would like to discuss in relation to the rights of the LGBTQ community. So, in that connection, we will discuss first the judgment delivered by the Delhi High Court in Naz Foundation case, then the second one in Jennifer Thomas case. So, in Naz Foundation case, Delhi High Court made an historic verdict in 2009, which took fast bold step of decriminalizing Section 377 of the Indian Penal Code, declaring it to be violative of the Constitution. The division bench of Ajit Prakash Saha, the Chief Justice, and Justice S. Muralidhar read down Section 377 to hold that the provisions will be attracted in cases of non-consensual penile, penile non-vaginal sex and penile non-vaginal sex involving minors. The court stated that where society can display inclusiveness and understanding, such persons can be assured of a life of dignity and non-discrimination. Further, in the Jennifer Thomas case, the Delhi High Court grants legal protection to a trans woman facing gender dysphoria. So, in Jennifer Thomas versus State of National Capital Territory of Delhi in 2024, where a petition was filed by an individual who identified as a woman but was assigned male at birth, seeking legal protection and support due to the distress caused by her gender dysphoria and the apprehensions about her safety and well-being. A division bench of Justice Suresh Kumar Cat and Manoj held that since the petitioner is major and is not at all interested in going back to the residence of her parents, she is at liberty to go back wherever she wants to stay. The petitioner has been experiencing significant distress due to her gender dysphoria and has expressed a desire for gender affirming medical treatment. Her situation became critical when she reported anger outbursts, anxiety, and apprehension of impulsive self harm, leading her to seek medical assistance at the Institute of Human Behavior and Allied Sciences. The clinical evaluation at the institute diagnosed her with gender dysphoria and adjustment issues, and she was advised to undergo supportive therapy. Then, in the Madras High Court judgments in particularly will discuss the Arun Kumar's case, then S. Sushma case, then S. Tamil Slave case. So, in particularly in the case of S. Arun Kumar case, so in particularly in the case of Arun Kumar, which was decided in 2019 by the Madras High Court, which held that a marriage solemnized between a male and a trans woman, both professing Hindu religion, is a valid marriage in terms of Section 5 of the Hindu Marriage Act 1955, and the Register of Marriages is bound to register the same. While holding so, the court expressed that this court is not breaking any new ground. It is merely stating the obvious. Sometimes to see the obvious, one needs not only physical vision in the eye, but also love in the heart. And in the Susama versus State in 2022, the Madras High Court expressed relating to rights of the LGBTQ community. Justice N. Anand Venkatas observed that 6 months' time served by the Tamil Nadu government to finalize the transgender policy and the rules is completely unacceptable, and this shows that priority is not being given to this case. So it is to government to appreciate the concern shown by this court as it was expressed by Justice N. Anand Venkatas. Then in another important leading case, Madras High Court issues interim direction for proper recognition of the LGBTQ community's rights and their safety. So, in that case, Sushma versus Commissioner of Police in 2021, Justice Anand Venkatas in Madras High Court issued interim direction for proper recognition of the rights of the LGBTQ community and to ensure their safety and security to lead a life of their choice. The bench itself went under a counseling session and gained a great amount of insight and understanding and felt that further interaction with persons who belong to the LGBTQ community would be greatly instrumental to help myself understand the ground realities, emotions, social discrimination, and exclusion, and several other difficulties faced by the community. And in another important leading case, that is relating to uh, relating to S Tamil Selvi case, and that is another most important landmark judgment where a writ petition filed for culling the records of the prospectus issued for the post basic nursing course and post basic diploma in psychiatric nursing course for the academic year 2022 and 23, and to quash the same as illegal for not categorizing transgenders under special category, and further to direct the respondent to admit the petitioner in the said course under special category as transgender. So, in the very judgment of R. Suresh Kumar, the justice in this important leading case, as Tamil Selvi versus Secretary to Government of Tamil Nadu in 2022, directed the respondent to treat the petitioner as the third gender or transgender and accordingly place her in a special category for the purpose of admission to the said course for which the merit list has been issued. And now we will go to the judgments delivered by the Karnataka High Court in relation to LGBT community. So the first case that we will discuss is Christian Luvo case, and the second one is relating to Malati SB case. So in Christian Luvo case, John Michael Guna, the judge of the Karnataka High Court in this Christina Lobo versus State of Karnataka in 2020, while allowing the present writ petition moved by a transgender against the declaration of herself identified gender in official documents, reiterated the to clarify upon the applicability of Rule 6.7 of Transgender Persons Protection of Rights Rule 2020, the transgender persons who have officially recorded their change in gender, whether as male, female, or transgender, prior to coming into force of the Transgender Persons Protection of Rights Act 2009 shall not be required to submit an application for certificate of identity under these rules, provided that such persons shall enjoy all rights and entitlements conferred on transgender persons under the said act. And in another important leading case, that is Malati, as we versus State of Karnataka in 2023, wherein the petitioner had allegedly been involved in mentally harassing a person vis-a-vis his sexual orientation, thereby leading him to commit suicide. So the very bench, consisting Justice M. Naga Prasanna, rejected the petition, stating that there is no need of interference of the High Court under Section 482 of the Criminal Procedure Code, that stating that the court opined that the instant case is not a case where there is no prima facie material or the allegations are made in thin air. Cases which involve death of a person and the accused are guilty of abetment to suicide of the said victim will have to be considered owing to facts of each case. There cannot be any particular parameter, yardstick, or a theorem for interference, particularly in cases of abetment to suicide. The court further emphasized on the fact that this is belong to the LGBTQ community, the sensitivity of them being ostracized, forwards in their sight. Therefore, such people must be treated with all love and affection and not point at the infirmity that they have no control of. If every citizen would treat such citizens with all love and care as is done to a normal human, precious lives would not be lost. Unfortunately, the precious life of a youth is lost in the case at hand, all for the prima facie allegations of pointing at sexual orientation of the deceased. And now we'll discuss another major judgments delivered by the Kerala High Court, and in particularly under the judgments delivered by Kerala High Court leading to the rights of LGBTQ community. First one is Sherina Hakim case that we'll discuss, then Kerala NGO case, then Hina Hanifa case, also Shiraz S case, and the last one is Jihad case of 2025 that we'll discuss. So the first one is Serena Hakim versus State, which was decided in 2024, which was a writ petition filed by the parents of a 23-year-old member of the LGBTQ community residing with her transgender partner, praying that her custody be given to the state so that she may be committed to the medical district board to undergo psychological evaluation to treat her sexual orientation. The division bench of Raja Vijay Bhargavan and Justice P.M. Manoj, while upholding petitioners' daughter's right of choice and right to live on her own terms, said that sexual orientation of a person is an innate part of a person's identity, and that the petitioner's daughter was an adult who consented to living with her partner. And another important landmark judgment delivered by the Kerala High Court by Justice V. Kunikrishnan in Kerala, an organization for Malay LGBTQ community versus State of Kerala, directed the Kerala government to take strict action against forced conversion therapy of LGBTQ community in the state. The bench also directed the state to constitute an expert committee and form a guideline based on this regard. And in the next important case, that is the case relating to Hina Hanifa case, where in particularly the historic judgment which was delivered by Justice Anu Sibraman in 2021 broke the norm by allowing trans women to appear for enrollment in the National Cadet Corps female wing. The bench remarked petitioner who has opted for the female gender and has undergone sex reassignment surgeries for aiding her self-perception as a member of the said gender would definitely be entitled to enrollment in the National Cadet Corps unit, reckoning or as a transgender and further as a member of her self-gender, that is the female gender. And in another important leading case, that is Srija S. versus Commissioner of Police in 2018, Justice C.K. Abdul Rahim and Justice R. Narayan Pischadji, while hearing a habeas corpus petition filed by the partner of a lesbian, held that persons of the same gender are entitled to be in a live-in relationship. The question before the court was whether the detainee could be permitted to go along with the petitioner to lead a live-in relationship because both of them belong to the same gender and could not solemnize a valid marriage between them. The bench held that live-in relationship between petitioner and the detainee would not offend any provision of the law and directed the detainee to be set at liberty to go along with the petitioner as desired by her. And in the last important leading case, that is Jahad versus State of Kerala, which was decided in this year 2025, which was a writ petition filed by a transgender couple seeking issuance of a birth certificate for their child as them parents and not as mother and father. A single judge bench of the High Court allowed the petition, holding that the concerns raised by the petitioners were valid as the issuance of the certificate in the prescribed form would cause serious difficulties to the child in life. At the court reiterated that the law must evolve in tandem with new concepts of human life and social changes. When a statutory provision on a particular point is not in line with such social changes, the court must intervene to address the genuine grievances of the parties concerned. And now we'll discuss another important judgment delivered by the Odisha High Court, and that is relating to Kanta Rao Kondagiri case, and in particularly Justice A.K. Mahapatra in this important leading case Kanta Rao Kondagiri versus State of Odisha in 2022 directed to process the application for grant of family pension to the transgender women as expeditiously as possible, preferably within a period of 6 weeks from the date of communication of a certified copy of the order. The court opined that the petitioner, as a transgender, has every right to choose her gender, and accordingly she has submitted her application for grant of family pension under Section 56, Subsection 1 of Odisha Civil Services Pensions Rule 1992. And now we'll discuss about the judgments delivered by the Andhra Pradesh High Court, and in particularly in Matam Gangadhar Bhavani. So, in this important leading case, considering that the direction issued by the Supreme Court in National Legal Services Authorities versus Union of India, it is suffice to provide reservation in cases of admission in educational institutions and for public appointments. The bench in this important leading case, Matam Ganga Bhavani versus State of Andhra Pradesh, in 2022 refused to issue any direction to the state to provide reservation to transgender. However, the directions were made to the state to study the representation of transgenders for public employment, their number in the state, benefits extended to them without discriminating from men and women, and provide necessary reservations if they are not represented adequately in the public employment. And now we'll go to the judgments delivered by Madhya Pradesh High Court, in particularly the Nuri case, which is an important case. So in this particular landmark judgment, the division bench of Muhammad Rafiq, the Chief Justice, and Vijay Kumar Shukla, the judge in this important leading case, Nuri versus State of Madhya Pradesh, gathered that most of the transgenders face difficulty not only because they do not have transgender identity card, but even the ration card were also not issued in their names. It was demonstrated that owing to non-availability of ration card, the transgenders community were not in a position to get their Aadhaar card issued. The court, while taking in community, were not in a position. So regarding the situation faced by the community, it directed the Madhya Pradesh State Legal Services Authority to provide assistance to all such transgenders across the state through the parallel volunteers and help them in getting their ration cards and transgenders cards and Aadhaar cards prepared. The respondent state is directed to place on record the relevant material showing other benefits which are being provided to the transgender community in the state of Madhya Pradesh under any other scheme of the central government or state government. And now we'll go to discuss another important landmark judgment delivered by the Patna High Court, and that is relating to Law Foundation case. So, in this important landmark judgment in Law Foundation versus State of Bihar in 2022, the division bench consisting Chief Justice Sanjay Carol and Justice S. Kumar has observed that certain measures have been taken in watching and protecting the interest of transgender community who are in conflict with the law, and a separate cell in the jails is earmarked for lodging the inmates hailing from such a community. Further directed certain instructions to the state. The court directed that the state shall ensure that the guidelines issued by the Government of India and adopted by the State of Bihar in relation to housing the members of the transgender community in jails shall be implemented in letter and spirit. And now we'll discuss another landmark judgment delivered by the Uttaranchal High Court, and that is Madhu Bala case. So, Justice Sat Kumar Sharma in Madhuwala versus State of Uttaranchal in the year 2020, while addressing a habeas corpus petition, observed that the intimacy of marriage included the choice of partner which individual make on whether or not to marry and whom to marry, at the aspect which exclusively lies outside the control of the state or the society. Consensual cohabitation between two adults of the same sex cannot be illegal, far or less a crime, because it is a fundamental right which is being guaranteed to the person under Article 21 of the Constitution of India. And now we'll discuss The last most important judgment delivered by the Punjab and Haryana High Court in the leading case, Paramjit Kaur case. So, here Justice Arun Monga in this important leading case, Paramjit Kaur, Bhas State of Punjab in 2020 addressed a matter wherein two girls were in live-in relationship and were constantly receiving serious threats from their families due to which they fled for protection. Petitioners sought direction to the official respondents to protect their life and liberty as they apprehend threat at the hands of private respondents. Number 4 to number 10, both the petitioners are girls and they are both major, having mutual liking for each other. They both have been in live-in relationship for the past 6 months. Court added that what is perhaps coming in the way of the petitioner is social unacceptability of the relationship by their parents or family members owing to which they are living under constant fear. So the petitioner, which are not being repeated for the sake of privacy, so they are entitled to protection of their lives as envisaged under Article 21 of the Constitution, regardless of the relationship between them. So, in this lecture, we have discussed almost 10 important high courts who delivered landmark judgments on the fundamental rights and legal rights of the LGBTQ community. So, at first, we have discussed the very position of the LGBTQ community as it was found in the mythological traditions of India and how it was continuing since the Middle Ages and up to Delhi Sultanate and the Mughal period, and finally when the Britishers they came to India. As per their Bagari Act of 1533, they inserted unnatural offences among the same sex or same gender as an offence which was punishable by death sentence under the Bagari Act of 1533 that they inserted into Indian Penal Code under Section 377, considering it is an offence and unnatural offence. So, finally, we have discussed the very development made in the field by the landmark judgments delivered by the Delhi High Court and Supreme Court in Naz Foundation case, then subsequently in the case of National Legal Services Authority versus Union of India, and finally the most landmark judgment on the fundamental rights of the LGBTQ community, that is the Navtesh Singh Johar versus Union of India, which was delivered in 2018 by the Apex Court. In connection to that, we have also discussed and made reference to the Mental Health Care Act of 2017, the Transgenders Persons Protection of Rights Act 2019, and also made a brief reference to the 2020 Labor Code concerning occupational health, safety of and social welfare of the transgender community in that particular code. So finally, we would like to conclude our lecture on this very important topic, that is relating to the fundamental rights of the LGBTQ community and the concerned High Court judgments in particularly the judgments delivered by the Delhi High Court, then Madras High Court, Karnataka High Court, Kerala High Court, then Odisha High Court, Andhra Pradesh High Court, Madhya Pradesh High Court, then Patna High Court, Uttaranchal High Court, and finally the decision delivered by the Punjab and Haryana High Court in Paramjit Kaur case. So, hereby we complete our lecture on this topic.